All right, good morning. A little different than good afternoon or good evening, but welcome to Kirk's Law Corner. Giving you guys an update, being missed Monday Night Law last night. Let some people get on here. Just want to give everybody an update of what's going on, why I wasn't able to make it last night, so you're all not worried. So one of my team members got arrested Sunday night unlawfully and taken to jail. Don't want to give too many details because that's how this works. You're not supposed to really talk about your case until after. And I know a lot of people don't quite comprehend that, but a lot of people want to put videos out and talk about what happened to them and but that's not due process of law. So essentially, we now have a right to a cause of action, which, I've been trying to basically get, but I technically speaking have two warrants for my arrest. I'll be fraudulently obtained, but they won't arrest me because I think they know that if they arrest me, then I'll get my right to a cause of action of what they're actually been doing. And I just want to give a brief rundown of the Idaho Code, right? Of how it's supposed to be. For those of you that have read the treatise on arrest and false imprisonment, you should know this already, that you cannot make an arrest without a warrant unless it's a felony happening directly in front of them. And for breaches of the peace, which is assault and battery, period. So, no further ado, we'll go right into this. Just want to share this here to kind of give you guys an idea of what I'm talking about, what we're going to be doing. We'll start with some basic rights, right? What are the rights? What was the conduct that violated the rights? And what are the damages? All men are by nature free and equal and have certain inalienable rights, among which are enjoying and defending life and liberty, acquiring, possessing, and protecting property, pursuing happiness, and securing safety. This is a key part to all of everything that we need to know. Enjoying. We have the right to enjoy life and liberty. That's that pursuit of happiness. It's a right. Okay. Coupled with the right to acquire, possess, and utilize our personal property. How we see fit out on the streets and highways. Our automobiles are our personal property. And enjoying, pursuing happiness and securing our own safety. Okay. That goes back to what I was shown before on Friday night. I believe this was the Pennsylvania Constitution. Yeah. Possessing and protecting property and pursuing and obtaining happiness and safety. Imagine that. It's almost exactly the way the Idaho Constitution is, right? and that no authority can or ought to be vested in or assumed by any power whatever that shall in any case, interfere with or in any manner control the right of conscience and the free exercise of religious worship. But it's the right of conscience. We get to think for ourselves, right? Or against his own free will or consent, nor can any man who acknowledges the being of God be justly deprived or abridged of any civil rights as a citizen. The government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community. Why doesn't it say state? Because state is about a state of being, free and equal, and having the liberty of conscience. That's our state of being. But, and not for the particular emolument or advantage of any single man, family, or set of men who are a part of only that community, bar members. And the community hath an indubitable, unalienable, and indefeasible right to reform. Reform, alter, or abolish government in such manner as shall be by that community judged most conducive to the public weal. Okay. Now remember, these are rights. We're talking about rights. This is a declaration of the rights. These are enumerated. That those who are employed in the legislative, executive business of the state, the body politic, that's that other part of the state of being, may be restrained from oppression. The people have a right at such periods as they may think proper to reduce their public officers to a private station and supply the vacancies by certain regular elections. That's what we're going to be doing here. We're going to reduce them back to a public station and make it so they can never hold an office of public trust again. And in all prosecution for criminal offenses, a man hath the right to be heard by himself and his counsel. My team member was deprived of the right to be heard, to demand the cause and nature of his accusation, deprived of that right, to be confronted with the witnesses to call for evidence in his favor in a speedy public trial, another couple of rights deprived. Without the unanimous consent of which the jury cannot be found guilty, nor can he be compelled to give evidence against himself. I don't answer any questions. That's a right to not answer questions, and they can't lose their mind, freak out, open your door, jerk you out of your automobile because you won't answer their questions. Nor can they confine you in a room that's made to torture. They're tortured my team member for 10 hours. No phone call, no water, no shoes, no socks, no coat, and make it freezing ass cold in there. And then come by there and bang on the door every 15 minutes for 10 hours straight. Mental anguish. Oh man, this is going to be huge. Nor can any man be justly deprived of his liberty except by the laws of the land or the judgment of his peers. Back to that. What? Without unanimous consent of a jury. Violations of rights there. That the people have a right to hold themselves, their houses, papers, and possessions, automobile, free from search and seizure. Well, when they towed her automobile off, they unlawfully seized her personal property without due process of law. Violation of rights. and therefore warrants without oaths or affirmations first made, affording a sufficient foundation for them, and whereby any officer or messenger may be commanded or required to search suspected places or to seize any person or persons, his or their property not particularly described, are contrary to that right and ought not to be granted. You got to go through due process of law. You've got to get a warrant to search and seize property or a man. Controversies respecting property. In suits between man and a man, the parties have a right to a trial by a jury, which ought to be held sacred. Except for they aren't doing suits between a man and a man. This is suit between a fiction and a corporate fiction, and the corporate Ponzi scheme they're running and using our straw man name in all capital letters. It's fraud. The people have the right to bear arms for defense of themselves and the state, and as standing armies in the time of peace are dangerous to liberty. These city police officers are standing armies. We have a right to be free from that. They ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power. Well, we dictate the way they're supposed to work, not how they think it should work. Now, this is the key part right here. That a frequent reoccurrence to fundamental principles, 2 + 2 = 4. You're either of sound mind, possessing logic and reason, and shall come to a reasonable conclusion based in reality, or you're insane. And a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty and keep a government free, as in we are self-governed. The people ought therefore to pay particular attention to these points in the choice of officers and representatives, and have a right to exact a due in constant regard to them from their legislatures and magistrates in the making and executing such laws as are necessary for the good government of the state. The people have a right to assemble together. What? The people have a right to assemble together. Now notice what the right to peaceably assemble is about. What's the subject matter jurisdiction here? What are we talking about? To consult for their common good, to instruct their representatives, and to apply to the legislature for the redress. We're talking about the legislature assembling together. This isn't about going to church. This isn't about a group protesting out in front of somebody's house. This has to do with calling the legislature in to consult to assemble, to consult for our common good, so we can instruct them under our petitions and remonstrances and address. Redress our grievances by and through address, 3 minutes, 2 minutes, whatever it is. Petition is a political lawsuit to alter, reform, or abolish. And the remonstrance is about policy making in the middle of making policy. That's a remonstrance. It's not a petition of remonstrance. Those are two separate things. Just like a Title 42, 1983 petition for violation of rights, like a petition for divorce. It's how we start a lawsuit. It has a prayer for relief. We get to demand our relief and instruct our representatives to discharge the duties of their office under those emoluments that the Constitution, the people, create. This is why you have to know what their duties are to perform, so that you know how to instruct them to discharge the duties of that office. Now, knowing what the common law says, this basic Magna Carta due process here, criminal procedure, arrest, by whom and how made. Arrest defined. An arrest is taking a person into custody in a case and in the manner authorized by law. An arrest may be made by a peace officer or a private person. Peace officer. These city police officers are not peace officers. They're under the Department of Transportation as policy enforcers for motor vehicles and drivers operating a commercial motor vehicle out on the streets and highways. And they're issuing uniform traffic citations. Traffic citations. And I'll show you. That they call misdemeanor criminal rules. No. This nisi pre-criminal. You cannot incarcerate or fine in a nisi prius court. Uniform citation. What's that? Peace officer citation. A peace officer may issue uniform citation for a citable offense in which the officer shall certify that the officer has reasonable grounds to believe and does believe that the person cited committed the offense contrary to law. The citation, blah, 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 blah. Idaho uniform citation. Okay, they're leaving out the word traffic. Right? Citizen citation. Uniform citation may be signed by any person in whose presence an alleged offense occurred and be witnessed by a peace officer whose name shall be endorsed on the citation. Service of a citation may be made by the defendant signing a written promise to appear on the citation at the time indicated. But if the defendant fails or refuses to sign the written promise to appear, or an electronic citation is issued, a peace officer may serve the citation on the defendant by personal delivery to the defendant and indicate such service on the face of the citation. Citation after arrest. The peace officer may arrest a defendant when permitted by law and thereafter sign the complaint in a uniform citation which shall constitute the complaint for prosecution of a criminal action. Oh, really? A rule of procedure doesn't work that way. It doesn't have the force and effect of law. Because it's not law. It's supposed to be rules of procedure, not a source of law. Now, watch this. Oh, where is it? This one? I thought it was number 4. Oh, here we go. Under failure to appear is where they hide this traffic citation. Failure to appear on a citation. In the event the defendant fails to appear at the time promised in the citation, the court may take one or more of the following actions. Now, if we have to promise to appear, that's entering into a contract. And they can't force you into a contract by saying, I'm serving you with this. Because watch. Notice to appear or pay fine. Oh, They have to send you a notice to appear or pay fine. Mail a notice to the defendant at the address stated in the citation requesting the defendant appear before the court promising the uniform traffic citation. It's a traffic citation. And these are bills of attainder. Exactly. This is exactly what our founders were talking about when they talked about these bills of attainder and bills of pains and penalties. They're also referred to as writs of assistance. These are alleged victimless crimes. There's no accuser. This is an officer of government, a public servant, that is trying to prosecute us by information, which is foreign to our form of government and repugnant to our law. But see, this is how they pull the wool over our eyes. This is the barcode scheme, scam, and fraud. They hide this shit. Excuse my language. They hide this stuff from us so that we don't know. We just freak out because we don't read. We don't know this stuff. We don't know what our rights are. We don't know the limitations of government, and we don't know how to read what it says right here. That these are, in fact, uniform traffic citations. They're under the Department of Transportation. Article 1, Section 8, Clause 3, the interstate and foreign, the Commerce Clause. And it is defined what a motor vehicle is, any contrivance used for commercial purposes. A warrant of arrest. Issue a warrant of arrest on the basis of the citation. The defendant fails to appear and pay the fine within the time set by the citation if probable cause has been shown as required by Rules 4 and 5 of the Auto Criminal Rules. So now they're skipping over to the Auto Criminal Rules. But this is misdemeanor criminal rules. No. Again, these are the bills of attainder and bills of pains and penalties they talk about. We need to abolish this. This cannot exist in our form of government. All of this right here needs to be abolished. Get rid of the rules of procedure, all of them. Get rid of the statutes that they think they have the power to make law. Now, an arrest, if we fully comprehend what an arrest is any deprivation of the right of liberty. If we read the treatise on arrest and false imprisonment, and then the authority of law backs up what I was just talking about. That these are supposed to be administrative nisi prius courts that do not have the authority to fine or incarcerate. None of these are arrestable offenses, and I'm going to show you. According to our own code. How is an arrest supposed to be made according to the statutes? An arrest is made by an actual restraint of the person of the defendant. Or by his submission to the custody of an officer. Okay? When they turn their emergency lights on, there better be an emergency. Like, I don't know, an ambulance or fire truck. If they use their emergency lights outside of the scope and authority, when there's not an emergency, that's a crime. For them, a public offense. But when these traffic patrol officers use their emergency lights for something other than an emergency, well, that doesn't apply to them. Uh-oh. But yeah, right here, it does. And when it says here, or by his submission to the custody of an officer, when he turns their lights on and you pull over, you're submitting to the custody, right? That's an arrest. The second you recognize those lights and start pulling over, that is an arrest of your liberty. The defendant must not be subjected to any more restraint than is necessary for his arrest and detention. And reading on the treatise on arrest and false imprisonment, they cannot handcuff you. When a peace officer may make an arrest, let's read this real good, because in the clear and plain language of the statute, they can't do what they did. A peace officer may make an arrest in obedience to a warrant delivered to him. That's right. There's only one warrant, has a wet ink signature from a magistrate that's already gone through due process of law. Without a warrant, arrest a person, or may without a warrant, okay, for a public offense committed or attempted in his presence. Public offense. That's for public servants. Like, I don't know, treason. When a person arrested has committed a felony, although not in his presence. When a felony has in fact been committed and he has reasonable cause for believing the person arrested to have committed it. Felony, felony, felony. On a charge made upon reasonable cause of the commission of a felony by the party arrested. At night, when there is reasonable cause to believe that he has committed a felony. In other words, anything less than a felony at night cannot make an arrest. Whereupon immediate response to report of a commission of a crime, there is probable cause to believe that the person has committed a violation of section blah, 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 assault, battery, domestic violence, which is assault and battery, first degree stalking, more breaches of the peace, violation of protection order. Protection orders can be not under domestic violence, through criminal. You can get a protection order through criminal process. Threatening violence upon school grounds, firearms, or other deadly or dangerous weapons, Idaho Code. That's it. Where there is reasonable cause to believe, based on physical evidence observed by the officer, statements made in the presence of the officer upon immediate response to report, a response to a report. So you got to have an accuser, a man that's not governmental public servant, of a commission of a crime aboard an aircraft that the person arrested has committed such a crime. On an aircraft. Where does it say that you can make arrests for traffic infractions? Where does it say that you can make arrest for misdemeanors? Oh, if it's assault and battery, an act of violence. And it only goes so far as stopping the assault or battery. You cannot take them to jail. Because watch. When a private person may make an arrest, it's the same. Because if I can't do it, they can't do it. For a public offense committed or attempted in his presence. Imagine that's the same damn thing. When the person arrested has committed a felony, although not in his presence. Same thing. When a felony has been in fact committed and he has reasonable cause for believing the person arrested to have committed it. Felony, 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 felonies. Felonies. Or a public servant is in violation of the public law. We can make an arrest if it happens directly in front of us. We have that power. That's a power retained by the people. Magistrate may order an arrest. A magistrate may orally order a peace officer or private person to arrest anyone of committing or attempting to commit a public offense in the presence of such magistrate. See? We have the power to make arrests. Now, here's a good one. I love this. Any person making an arrest may orally summon as many persons as he deems necessary to aid him therein. They didn't like it when I did that at the sheriff's office on December 24th, when I was there serving them with an 18-page lawful notification letter. and was telling them this crap's all a bunch of fraud and the fraudulently procured warrants, demanding them to bring them out and serve them on me and take me to the nearest and most accessible magistrate, like it says on the warrant, for an initial appearance, because you cannot incarcerate or require to post bond until after an initial appearance. That's due process of law. That comes from the common law, the law, not your code. But it even says it right here. When an arrest may be made, okay, upon warrant. If the offense charges a felony, the arrest may be made on any day at any time of the day or night for a felony. If the offense charges a misdemeanor, that's just for with a warrant, with the warrant. The arrest shall not be made inside a person's residence between 8 p.m. and 8 a.m. At night, you cannot make an arrest, even with a warrant, unless upon direction of the magistrate, as endorsed on the warrant, or where consent was given to enter the residence by a person with real or apparent authority. That's subverting the law. You can't make an arrest at night. And you have to take them before the nearest and most accessible magistrate. I'll show you. We'll get there. Information to person arrested. The person making the arrest must inform the person to be arrested of the intention to arrest him, of the cause of the arrest. What is the cause of action to make this arrest? And if it doesn't amount to an arrestable offense, you can't arrest them. You cannot deprive them of their liberty and the authority to make it. You have to tell them what crime they have committed and what your authority is to make that arrest. The law, not the code, not a rule of procedure. Except when the person to be arrested is actually engaged in the commission of or an attempt to commit an offense or is pursued immediately after his commission or after an escape. Warrant must be shown, because warrants have to go to the sheriff, and the sheriff has to hand that wet ink signature warrant to a man to execute and serve the warrant. If the person making the arrest is acting under the authority of a warrant, he must show the warrant if required. Key word, if required. I require it. I require you produce and serve me the warrant so that I may scrutinize that warrant and refuse it for cause for fraud. And then once I refuse it for cause, and the cause is for fraud, fraudulently obtained, and you take action under that unlawfully obtained fraudulent warrant, you become culpable because you just got put on notice that I'm refusing your unlawfully fraudulently obtained warrant on its face. What force may be used? When the arrest is being made by an officer under the authority of a warrant, or when an arrest is being made without a warrant, but is supported by cause of action, to believe that the person has committed an offense. No, a crime, not an offense, unless we're going to talk about public servants. After information of the intention to make the arrest, if the person to be arrested either flees or forcibly resists, forcibly, It's not resisting and obstructing when there's no force. Saying I don't answer questions is exercising the right to not incriminate himself. That's not force of violence. The officer may use all reasonable and necessary means to effect the arrest and will be justified in using deadly force under conditions set out in the section. Well, let's look at what that's authorized for deadly force, because remember, this applies equally to all of us. Homicide is justifiable, so it's not homicide. It's defense. Maxim of law. What a man does in his defense is to be considered legal. When committed by public officers and those acting by their command and their aid and assistance either. Oh, wait, only officers? No, screw you. Watch. In obedience to any judgment of a competent court. Competent court. Whoops. When reasonably necessary in overcoming actual resistance to the execution of some legal process or in the discharge of any other legal duty, including suppression of riot or keeping and preserving the peace. That's assault and battery. Use of deadly force shall not be justified in overcoming actual resistance unless the officer has probable cause to believe that the resistant poses a threat of death or serious physical injury to the officer or to other persons. So like a knife. You pull a gun out when you're in the wrong and being arrested, lawfully obtained warrant, whatever. They can use deadly force because that's a threat of death. You pull a knife out on them. That's a threat of serious physical injury. That's okay. So, when reasonably necessary in preventing rescue or escape and retaking inmates who have been rescued or have escaped from any jail, or when reasonably necessary in order to prevent the escape of any person charged with or suspected of committing a felony, provided the officer has probable cause to believe that the inmate or persons assisting his escape or the person suspected of charged with the commission of a felony pose a threat of death or serious physical injury to the officer or other persons. There has to be a threat. There has to be a threat of loss of life, of death. What's the procedure upon arrest without a warrant? When an arrest is made without a warrant by a peace officer or private person, the person arrested must, without unnecessary delay, be taken before the nearest and most accessible magistrate in the county in which the arrest is made, and an information stating the charge against the person must be laid before the magistrate. No, a criminal complaint must be laid before the magistrate under oath. You got to take the stand or in writing, signed under penalty of perjury. That's the common law. The law dictates that process, not the statutes. But like it says, you got to be taken without unnecessary delay. Be taken before the nearest and most accessible magistrate in the county in which the arrest is made. Doesn't say take them to jail. Does it? No, it does not. This goes back to basic Magna Carta due process. Magna Carta 1215, section 39. Now, Detention for obtaining evidence of identifying physical characteristics, your picture, fingerprints, that kind of stuff. Let's take a look at this right here. Detention for obtaining evidence. This is without unnecessary delay, right? First, right? So this would be a necessary delay. But what does it say? Detention for obtaining evidence identifying physical characteristics. Peace officer who's engaged with the scope, within the scope of his authority in the investigation of an alleged criminal offense, which is a felony, may make written application upon oath or affirmation to a judge of any district court or magistrate division thereof for an order authorizing the temporary detention for the purpose of obtaining evidence of identifying physical characteristics of an identified and particularly described individual residing in or found in the jurisdiction over which the judicial officer presides. The order shall require the presence of identified or particularly described individual at such time and place as the court shall direct for obtaining the identifying physical characteristic evidence. Such order may be issued by the judicial officer upon a showing under oath of all of the following. All of it. Probable cause or belief that a specifically described criminal offense, which is a felony, has been committed. Reasonable ground exists, which may or may not amount to probable cause to believe that the identified or particularly described individual committed the criminal offense. Felony. Procurement of evidence of identifying physical characteristics from the identified or particularly described individual may contribute to the identification of individual who committed such offense. But see, again, you got to get that warrant to search and seize this information. Such evidence cannot otherwise be obtained by the investigating officer. Whoops. So when they take you to jail, that violates your right to due process of law. Then they unlawfully seize your person and identifying physical characteristics, fingerprints and picture. And then they publish that crap out on their little website, defamation of character. The alleged criminal offense, which is the subject of the application. An order issued, it's a warrant, order of arrest, issued pursuant to the provision of the section shall specify the following. So the warrant has to specify the alleged criminal offense, which is the subject of the application. Felony. He robbed a bank. I think he robbed the bank. We got some fingerprints here from the bank, and we want to seize this guy and search him to get these identifying characteristics. You got to go get a warrant for that. The specific type of identifying physical characteristic evidence which is sought. They have to put it in writing. What do you want? Fingerprints? Are you wanting blood for DNA tests for, say, like a rape? They have to go get the warrant, and it has to specify the type of identifying physical characteristic evidence which is sought. They can't just arbitrarily do that. The relevance of such evidence to the particular investigation, the identity or description of the individual who may be detained for obtaining, they have to describe you in the warrant. Oh, that's right. That's the Fourth Amendment, ain't it? The name and official status of the investigative officer authorized to effectuate such detention and obtain such evidence. A traffic patrol officer is not authorized to do that. When he's in his official capacity as a traffic patrol officer, his scope and authority is for motor vehicles acting in commerce for drivers. And again, is administrative and in no way can be criminal. not in his official capacity. Now, if he sees like a bank robbery going on, okay, that's outside his scope and authority. Now he's down to his private station, individual capacity, and now he can make the arrest for a felony happening directly in front of him because he's not a peace officer. He is a traffic patrol officer at best, because otherwise that's a standing army and they shouldn't be armed. Should not be an armed body of men. The place at which the obtaining of such evidence shall be effectuated. Well, we'll do that over at the 80 County Jail, or we're going to go do that over here at the hospital, over in a forensics lab. You have to describe the place at which the obtaining of such evidence shall be effectuated. Well, we do fingerprinting and photographs at the county jail. Okay, that has to be in the warrant to dictate that that's where that's going to be done. You can't just arbitrarily subvert this. The time that such evidence shall be taken, except that no person may be detained for a period of more than 3 hours for the purpose of taking such evidence. 3 hours without unnecessary delay must be taken before the nearest and most accessible magistrate. That the individual so identified or described in the warrant shall have the right to legal counsel during the detention when such evidence is obtained. Notice it doesn't say a member of the bar. Right? Because we go back to these, return to these fundamental principles of our rights, the law. Where is it? Right here. A man hath the right to be heard by himself and his counsel. Doesn't say a member of the bar, does it? Considering the American Bar Association wasn't even created until 1878. Oh my gosh, what did we do for assistance of counsel prior to 1878? We have the right to choose who our counsel is. That's a right retained by the people. It's an enumerated right here. This isn't constitutional law. This is the common law. As bills of rights, plural. American Jurisprudence, Volume 16. Constitutional Law, Section 100. Bills of rights and those merely declaratory of the common law. This is merely declaratory of the common law. American common law, not the English common law. We're in America. We're not in Great Britain. We adopted the English common law and only those parts of it, such as rights as the law and parliamentary practice, and only certain parts of that. So, that the individual may be under no legal obligation to submit to any interrogation or to make any statement during the period of his appearance unless sound of voice identification is required. Well, that would have to be in the warrant now, wouldn't it? Describing, we want you to, here's a piece of paper with some words on it. We need you to read this for us. And we want to take an audio sample of your voice. Got to be described and where it's to be done. The period of time not exceeding 10 days during which the order shall continue in force and effect. If the order is not executed within 10 days, a new order may be issued pursuant to the provisions of this section. For the purpose of this section, the identifying physical characteristics shall mean fingerprints, palm prints, footprints, measurements, handwriting, handprinting, sound of voice, blood samples, urine samples, saliva samples. Oh, like for COVID, saliva samples, hair samples, comparative personal appearance, or photographs of an individual. You're in violation of due process of law. Arrest with certified copy of a warrant. Any arrest that may be lawfully made with an original warrant may be made with a copy thereof, certified by the issuing magistrate to be a true and correct copy of the original warrant that is in his possession. Which means they got to go back to the magistrate with a copy and go, can you certify the copy of this? I'm going to go execute this. Because that's what it says in the clear and plain language of the statute. So, here's a good one. Force for purpose of liberation. Oh boy, this is going to get good after I go from here. Any person who has lawfully entered a house for the purpose of making an arrest may break open the door. Now, pay attention to what's being said here. Or window thereof, if detained therein, when necessary for the purpose of liberating himself. And an officer may do the same when necessary for the purpose of liberating a person who, acting in his aid, lawfully entered for the purpose of making an arrest and is detained therein. Now, where is it? Oh, I think it's right in here. The preliminary provisions. Legal conviction necessary to punishment. Oh, that's right. So you can incarcerate or post. No person can be punished for a public offense except upon legal conviction in a court having jurisdiction thereof. Uh-oh. Oh, prosecution by indictment or information. No. This subverts the Sixth Amendment. Every public offense must be prosecuted by indictment or information except where proceedings are had for the removal of civil officers of the state. Oh, really? Wait a minute. So we don't have to get a criminal indictment or an information for the removal of civil officers. Offenses arising in the militia when in actual service and in the land and naval forces time of war, but you got to be in the military or militia, or which the state may keep with the consent of Congress in time of peace. Offenses tried by justices and probate courts. Tried in justices courts of justice? That's the legislature. The judicial branch does courts of law, not courts of justice. They've lied to us. That's why we petition the legislature for the redress of grievances, because that's where we establish justice, in the court of justice, in the legislature. It's where we also do the trials of impeachment, in the court of justice, not courts of law. Article 3, Section 2, suits in law and equity. In having to do with lands, because that's what it says as it is written. In law, incorporated into the body politic, and more specifically, the checks and balances of the judicial branch providing oversight of the legislature. That's what a suit in law is. Hey, is this constitutional or not? Not to interpret the Constitution, but to interpret what the legislature has made to see if it comes in conflict with the letter of the law as it is written. What's a criminal action? The proceedings by which a party charged with a public offense is accused and brought to trial and punishment is known as a criminal action. Public offense. All right, so it's not what I'm looking for exactly. Prevention. It may be this one. Oh, yeah. Boy, this gets good, guys. Lawful. Notice it's lawful, not legal. Lawful resistance. Lawful resistance to the commission of a public offense may be made by the party about to be injured or by other parties. Uh-oh. Lawful resistance, like the right to defend your life and liberty and come to the aid of your fellow man who is about to be deprived of their life and liberty, because that would be a public offense by a public servant. We have the right to lawful resistance, and boy, does it get good. Now, this is what I'm talking about. The legislature making policy. Oh, the Castle Doctrine and stand your ground. It is the intent of the legislature to incorporate provisions of the Castle Doctrine and stand your ground, provide an idle case law and jury instructions in a certain section of this chapter and in section 18-409. Back to that one I just showed. Idaho Code. Castle Doctrine. How about the law? That the people have the right to bear arms for the defense of themselves and the state. It's already the law. It's already the law. Right says the law. What do we need a policy for to say what it already says as our right? Resistance by threatened party. Uh-oh. Resistance sufficient to prevent the offense may be made by the person about to be injured, to prevent an offense against his person or his family or some member thereof, to prevent an illegal attempt by force to take or injure property in his lawful possession. Oh, man, I almost want to answer this. A person acting pursuant to this section may use such degree and extent of force as would appear to be reasonably necessary to prevent the threatened injury. Reasonableness is to be judged from the viewpoint of a reasonable person placed in the same position and seeing and knowing what the person then saw and knew without the benefit of hindsight. What was going on at the time? You got to put yourself in their shoes. Is this something that you would do? Or is it reasonable that is something that you would do? Because the maxim of law is what a man does in his defense is to be considered legal. That's the fundamental principle, the rule of law. Defense of self, others, and certain places. No person in this state shall be placed in legal jeopardy of any kind whatsoever for protecting himself, his family by reasonable means necessary, or when coming to the aid of another whom he reasonably believes to be in imminent danger or the victim of aggravated assault, robbery, rape, murder, or other heinous crime. What is an aggravated assault? Well, let's take a look at aggravated assault or aggravated battery. Aggravated assault defined. Let's take a look at this. Aggravated assault is an assault with a deadly weapon or instrument without intent to kill or by any means of force likely to produce great bodily harm. With any vitriol, corrosive acid, or caustic chemical of any kind. You know, that spray stuff they carry, or that electronic device there, you know, the taser thing. Uh-oh. Deadly weapon or instrument as used in this chapter is defined to include any firearm, though unloaded or so defective that it cannot be fired. Uh-oh. Oh, no. Because how does the potential victim here know whether or not that that weapon or instrument is unloaded or that it doesn't work? So that means every single city police officer that pulls you over, it's automatically aggravated without intent to kill. It still becomes aggravated by any means of force likely to produce great bodily harm, or with any vitriol, corrosive acid, or caustic chemical of any kind, deadly weapon or instrument. Remember, this is definitions. As used in this chapter is defined to include any firearm, though unloaded or so defective that it cannot be fired. You better have lawful authority. Same thing with aggravated battery, except that they kind of leave that out. But person commits aggravated battery who, in committing battery, causes great bodily harm, permanent disability, or permanent disfigurement, uses a deadly weapon or instrument, or uses any vitriol, corrosive acid, or caustic chemical of any kind, of any nature, uses any poison or other noxious or destructive substance or liquid upon the person of a pregnant female, causes great bodily harm, permanent disability, permanent disfigurement. Embryo. Purpose of this section, the terms embryo or fetus shall mean any human in utero. Okay, but then abortion is okay. Oh, wait. Of any person for conduct relating to an abortion, for which the consent of the pregnant female or person authorized by law on behalf of shall obtain, for which such consent is implied by law. Any person for any medical treatment of pregnant female. Oh, there shall be no prosecution under subsection 1 of this section. Under this section. Let's see. What is the punishment for aggravated battery? Aggravated battery is punishable by imprisonment in the state prison not to exceed 15 years. That's a felony, folks. That's an arrestable offense without a warrant. Okay. The defense of self or another. Oh, wait. A family member who's reasonably believes to be in imminent danger, the victim of aggravated assault, robbery, rape, murder, or other heinous crime. That's felony. The defense of self or another does not require a person to wait until he or she ascertains whether the danger is apparent or real. A person confronted with such danger has a clear right to act upon appearances such as would influence the action of a reasonable person. In the exercise of the right of self-defense, if it's a right, why do we need castle doctrine? Why do we need any policy if it's a right of self-defense or defense of another? A person need not retreat from any place that person has a right to be. The person may stand his ground and defend himself or another person by the use of all force and means which would appear to be necessary to a reasonable person in a similar situation with similar knowledge without the benefit of hindsight. The provision of this subsection shall not apply to a person incarcerated in jail or prison facilities when interacting with jail or prison staff who are acting in their official capacities. Yeah. So long as they're acting in their official capacity. You step outside your official capacity, you're damn right you have the right to come to your aid and defense. Man comes into like the female cell or something, decides he wants to rape this woman. All the other women around have the right to come over and beat the crap out of this man to stop it. All right. Let's see. In any prosecution for the unlawful use of force, including deadly force or the attempted or threatened use of force contrary to Title 18, blah, 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 the burden is on the prosecution to prove beyond a reasonable doubt, unanimous consent, all 12, that the use of force, attempted use of force, or threat to use force was not justifiable. A person using force or deadly force in defense of habitation, place of business or employment, or occupied vehicle, as defined in Idaho Code, is presumed to have acted reasonably and had reasonable fear of imminent peril or death, or serious bodily injury. If the force is used against a person who entry or attempted entry therein is unlawful and is made or attempted by use of force or in a violent or tumultuous manner or surreptitiously, yeah, that one, or by stealth or by the purpose of committing a felony. We have the right, fundamentally and principally, to defend ourselves, to defend our neighbors, family members, our animals, our land, our personal property, no matter where we're at. We have the right to come to the aid and defense of our fellow man at any time, no matter who it is, and no matter what disguise they're wearing. At any time. It's time to start holding these people accountable. And I'm going to reiterate, I do not advocate for the use of violence, but I'm just reading what it says in the clear and plain language of the statutes, that this is a very, very apparent right. And I know the system is rigged, and how if you try to defend yourself and shoot these guys, you're going to get charged, right? But there's been recent cases where, like the one there, can't remember where it was at, but the SWAT team was serving a search warrant, and they kicked in the door of the wrong place, and the man shot him dead. Well, when it went to court, they had to produce the warrant describing the particular place to be searched and seized, and They had the wrong address. And they said, well, no, that man has every right to defend himself and his home and his family. You made the mistake and went to the wrong house. You had no lawful authority to kick that man's door in. Sucks to be you. You should have read the warrant and verified that you had the right place. But you have to know your rights. You have to know this, because the claim and exercise of a right cannot be converted into a crime. Miller versus U.S. Now, to go back to fully comprehend this right, the people have the right to bear arms for the defense of themselves and the state of being free and equal. This is why crimes. Civil rights. Conspiracy against rights. 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in state, territory, commonwealth, possession, district, free exercise, or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of his having so exercised the same. If 2 or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, shall be fined under this title or in prison not more than 10 years. That is a felony. We're free and equal. So no matter what you're clothed with that disguise, it's a disguise. It doesn't matter. That's color of authority. And let's read and put you all on notice. And if death results from the acts committed and violated this section, or such acts include kidnapping, you had no lawful authority to make that arrest. If you didn't follow due process of law and take them before the nearest and most accessible magistrate, it's kidnapping or an attempt to kidnap. Aggravated sexual abuse or attempt to commit aggravated sexual abuse or an attempt to kill, they shall be fined in this title or in prison not between terms of life or both, or may be sentenced to death. Now, under kidnapping in general, is not. But what we're talking about here is public servants who go out in disguise on the streets and highways or on the premises. We have the right to be secure in our homes or in your automobile. And they violate your rights and take you to jail. That's kidnapping. And if it involves kidnapping, see, they have to be together, which means a public servant wearing a disguise, whether it's a policy officer uniform, whether it's a military uniform, whether it's a sheriff deputy uniform, whether it's a FBI agent, CIA agent, any disguise. And they take you where you don't want to go, that amounts to kidnapping. This is a public offense. Deprivation of rights under color of law. What law are they acting under? I just read to you the statutes. Whoever, under color of any law. What's color of law? Statute, ordinance, regulation, or custom. Those rules of procedure. Willfully subjects any person in the state, territory, commonwealth, possession, or district of deprivation of any rights, privileges, or immunity secured or protected by the Constitution. They're not constitutional rights. These are common law rights. These are those unalienable rights. Right? Back to this again. Where is it? That all men have a natural and unalienable right to worship God, dictates of their own conscience and understanding that no man ought or of right can be compelled to attend any. The government is ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument or advantage of any single man, family, or set of men. Policy officers, sheriff deputies, CIA, FBI, Bureau of Land Management, Fish and Game. Those are all disguises, remember, who are part of only that community, and that the community hath an indubitable, unalienable, and indefeasible right to reform, alter, abolish the government in such manner as shall be by that community judged most conducive to the public weal. Talking about them unalienable. I don't think there's, yeah, that's it. So, let's see. Or to different punishments, pains, or penalties, like locking somebody in a room because they won't answer your questions for identifiable information, characteristics. You need to produce a driver's license. No, you got to go get a warrant. You want me to produce picture identification to identify myself, you're going to have to go get a warrant. Specifically describing that, what you're wanting to search and seize for. Otherwise, you can only pull over commercial motor vehicles for a driver who is operating a commercial motor vehicle on the streets and highways. Pains or penalties, bills of pains and penalties, different punishments on account of such person being an alien or by reason of his color, race, than are prescribed for the punishments of citizens. But that's the or, right? Whoever under color of any law, statute, or subjects any person in the territory to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution, laws, or punishments, pains, or penalties on account of such person being an alien. Technically speaking, that we're the aliens, right? We're not public. We're foreign to the public law. We're in the private. Or by reason of his color. That's the or. It's or. Or both. Or if bodily if bodily injury results from the acts committed in violation of section or such acts include the use of same thing, attempted use or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title in prison not more than 10 years or both. So felony. And if death results from the acts committed in violation such as include kidnapping or attempt to kidnap, aggravated sexual abuse, or attempt to commit it under this title in prison not more than 10 years or life, term of life, or for life, or both, or may be sentenced to death. This is some serious business, folks. Those involved in serious human rights violations, human trafficking, and corruption may be sentenced to death, especially where it involves the attempt to kidnap or actual kidnapping. So, now that we're fully aware, at least as far as I'm going to cover today, again, the defense of self or another person does not require a person to wait until he or she ascertains whether the danger is apparent or real. Right? Ha ha ha. Uh-oh. Well, now, let's see. Whoops. Let's take a look at this. By the U.S. Marshals, February 23rd, 1861. President-elect Abraham Lincoln quietly slipped into Washington, D.C. to prepare for his inauguration on March 4th. Accompanying him was U.S. Marshal Ward Hill Lamont, DDC, a friend and former law partner. Huh. Why would the U.S. Marshals tweet that? Let's read between the lines. Quite interesting that the U.S. Marshals would dig up something from history and post it in this time. I don't know. I guess we'll see what happens, right? So if you'd like to help support the channels here and keep the bills paid, I'd greatly appreciate it. Oh, crap. For those postal money orders, regular money orders, cashier's checks, cash wrapped in aluminum foil, gold, silver coinage, popcorn. Through the snail mail, if you'd like to send that through the snail mail over there to the office, 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. Digital side, PayPal, Kirk_Pendergrass, hotmail.com. My Cash App, $, capital K, capital P, EN71. It is case sensitive. And of course, over on Patreon, you can get subscribed up over there for a monthly reoccurring donation, basically, to help support that. And to my patrons over there, I will be doing tomorrow for you guys. So I'll get something posted on there to let you know. I think I'm going to move it to 5 p.m. Mountain Time, 4 p.m. Pacific, and that'll be 7 p.m. Eastern. So there's a couple people that can't make the later time, so I'm going to bump it up a little bit so they can make it. And again, that'll be open to all patrons on there. And we'll get the Patreon going for everybody that can be there tomorrow, Wednesday night, 5 p.m., 4 p.m. Pacific, 7 p.m. Eastern. So 5 p.m. Mountain Time. All right. Yeah, things are definitely heating up for us at the office and the team, especially with what we served there in the lieutenant governor on Thursday last week. So, yeah, I would greatly appreciate the support financially, because this is going to start costing money as we start going to federal court under Title 42, 1983 for civil rights violations, as well as the criminal side. The criminal side shouldn't really cost us any money, but when we go to the federal side, that's going to be $400 to start, plus all that. I mean, everything that it's going to take, ink, paper, all that good stuff, plus paying the rent and all that good stuff. So again, I greatly appreciate the support that you guys have given already, and it's been helping. And I think my team and those that are behind the scenes here, I greatly appreciate you. And let's have some prayers around for all those U.S. Marshals that are doing the things that they're doing and rescuing children, and anything else that they may be doing, and protect them, a hedge of protection. And pray for our fellow man, even our enemies. Hopefully they have a change of heart, right? We're supposed to even pray for our enemies. And I greatly appreciate the prayers for us and our team. and love and the support. I greatly appreciate you people. Great American patriots, we're here. We need to get educated, and we need to start standing up against this crap. Or following due process law and file the proper paperwork. And, you know, the whole thing about Patreon over there is where I'm going to start teaching people how to effectively defend themselves, the proper paperwork and all that good stuff. So, yeah. So much love, everybody. I want to thank you all for being here. And I'll see my Patreon patrons on tomorrow night. And then, of course, the rest of you over here on Friday night fun night. All right. Hope everybody has a wonderful day, and stay safe. Much love, everybody.